Thanks everyone for coming. I had hoped when we started this program that we'd have topical and cutting edge sort of topics, and there is nothing more, I think you'll all agree, cutting edge or topical than this question of section 44 at the moment. We're losing politicians at a rate of knots because of
potentially losing them. Potentially.
Well, we've had 2 resign, we've had some quit cabinet, and more with big question marks over their head. But before I start, I noticed Brian Burdigan here. For those of you who haven't met him, his name's on our door at the front. So he's an esteemed colleague. He was the first Federal Human Rights Commissioner, and he now spends his time just travelling the world and advising on things like human rights and constitutional law. So we're lucky to have him as part of our floor.
Coming to first nights like this.
Yeah, and he's good mates with Kenzie, so he thought he'd come along and support him. So today's topic, if you've read the paper, it starts in with the 2 great republics of ancient antiquity, Rome and the Athenian Republic. They both started around the same time, believe it or not. Athens got rid of their last despot in 510 BC, and the Romans got rid of their king in 509 BC. And then with different models, the Athenians had a direct form of democracy, as do the Swiss to this day. The Swiss public vote on everything from how much money they're going to spend on their school halls up until constitutional reform, so they vote a number of times every year. That was the type of direct democracy that the Athenians had. The Romans didn't quite have that form of democracy, but the institutions that we associate with the representative form of government today were found in the Roman Republic up until the time of Octavian, when he took the purple in 27 BC, and all of that disappeared. And the same with the Athenians, actually. Once the Macedonians stormed through in about 320 BC, they suppressed democracy. And there it was. It disappeared from the face of the earth for over a millennia. So it was a distinctly unsuccessful form of politics. And we didn't really see it again, certainly not in the Western world, until a Frenchman married the sister of King Henry III. And Simon de Montfort, for various reasons which I won't go into, he ended up capturing his brother-in-law, the king, and the king's son, Longshanks, who became Edward I, captured them. And he then called the first parliament. And he did this because he needed popular support. So what do? He didn't have authority himself. He wasn't a nobleman necessarily. But he looked to the counties and invited the knights of the counties and the burgesses from the various towns, and held a parliament in Westminster in 1265. And this parliament, because of the nature of it, because it involved the various people from the counties, it was called the Commons. So the Commons actually predated the House of Lords, and that's typically seen as being the first true parliament. But the weird thing about it is, I think, that after de Montfort was killed in battle about 12 months later, and then Longshanks became Edward I, he, having seen this model at work, decided to employ it himself. So by 1295, the English kings were actually calling parliaments, including the public, the people from the counties, etc., to attend. So it became an institution from very early on in the piece, and of course Richard will speak a little bit more on what has happened to it since then, but of course it's become a very popular and almost indispensable part of Western democracy, to the point where Amartya Sen, he was a Nobel Prize winner in economics, he made the statement famously that there are no famines in democracies, which is essentially been proven to be true. And Immanuel Kant similarly created what was called the democratic peace theory, institutions like liberalism and commercialism are very strong motivating forces, prophylactics against the commencement of war. So that's the introduction to a topic which I had asked Richard to speak on some weeks ago, and he very kindly agreed. We've been having a lot of fun since then talking about the ins and outs of this topic, and it's got its own interest, of course, which he will expand upon. But just to say a few words about our speaker, you've all met him, of course, but you may or may not know, you'll know if you pick up the CLRs, but Richard has done a lot of High Court cases, not just in labour law, but in constitutional law, in human rights law, and as it turns out, election law. One of the cases, or two of the cases mentioned in the paper, are called Wood. Richard acted in those decisions. They ended up being quite important decisions because they defined what it meant to be chosen by the people, which is a very expression which demonstrates that we are part of a representative democracy in Section 7 and 24 of our Constitution. So I will now hand over to our esteemed speaker, Mr. Richard Kenzie.
Thank you. That brief introduction will tell you a lot about the inspiration for the first part of our paper. And thanks are due to Tom. When he asked me to do this, I said a little help with the history it would be good, and he obliged, as you can see. This paper is provided in draft form for a number of reasons, the principal one of which is that as far as Section 44 is concerned, as we all know, the world is moving faster than the pen can follow currently. It's fair to say that our quest for a topical CPD subject was well and truly answered, and as we speak, Section 44 is looming like some unwanted guest at a party in political life in Australia, and again, as we speak, there are mega cases before the High Court or the Court of Disputed Returns due back in October, in which a number of the matters that are addressed in one way or another in our paper are rehearsed and are going to be re-rehearsed before the Court of Disputed Returns. In the early part of the paper, as you can see, and I know you've only had a little chance to look at it, we've briefly explored some of the history and the constitutional underpinnings relevant to the developments in both the UK and the USA, not necessarily the only areas that we could have examined, but relevant areas for obvious reasons, and to discern some of the differences that are involved in their underpinnings, and some of those differences, not all, factor into, we believe, into an understanding of the presence of Section 44 within the Constitution, as well as its interpretation. Now, we've tried, and in pages 2 to 8 of the paper, and you'll be delighted to know that I'm not going to follow the invitation of Tom and go too deeply into the comparative and comparative law history, but some of those areas we've tried to identify the differences in constitutional underpinnings existing as between the Australian and the US Constitution relating to the approach to sovereignty, the sovereignty of majority rule and direct participation of the citizenries. And we've referred in particular to the fact that the Australian Constitution is one that gives effect to a system of representative and responsible government, and we've tried to we've defined that in slightly greater detail on page 4 of our paper, where we explain that our government is representative because parliaments are directly chosen by the people, with the underlying principle which informs the core requirement that the system of representative democracy is that the rights of individuals are sufficiently secured by ensuring to each, as far as possible, an equal share in political power. and the Australian system, as we go on to say, is responsible because subject to the Constitution's federal structure, the Governor-General exercises executive power of the Commonwealth on the advice of his or her ministers, so they hold office for only as long as they have the confidence of the lower house of Parliament. Those sorts of thoughts have already fed into the interpretation of parts of Section 44, and again, I don't want to drill too far down, we're talking generalities here, but in Re-Day number 2, Justice Keane, who was interpreting Section 44.5, said that, which is the provision that relates to obtaining financial benefit whilst you're a member of the House, said that a provision such as Section 44.5 might be thought to be especially necessary in a constitutional structure in which the executive government is, unlike the executive government under the Constitution of the US, dependent for its survival upon the support of the legislature. So we do see that those underpinnings are going to feed and do feed into the actual debate and the forthcoming debate as to what the approach to Section 44 is going to be. Likewise, the question of whether any of the language of Section 44 should be construed narrowly has been resisted by the court in recent times. There have been appeals Senator Culleton, former Senator Culleton and Day, both invited the court to take a narrow approach to Section 44 because of its consequences, and the consequences are real. Those approaches have been resisted by the court in the particular context on the basis that the section protects matters fundamental to the Constitution, namely representative and responsible government in a democracy. And that was the approach taken by the plurality in Day number 2. And those matters are not without importance, because when we come to the debate that's forthcoming in October, you can bet your life, indeed we now know, that submissions are going to be made on behalf of various of the incumbents or the challenged politicians, which will invite, in one way or another, a reading or a further reading down of the provisions in the Constitution, so that there will be a tension between the matters raised by the plurality in Day and that sort of approach, which is one of the things that adds to the complexity. As we point out in page 4 of our paper, the framers fled from any idea of enshrining within the Constitution any notion or definition of citizenship or the establishment of a constitutional power relating to citizenship. Section 34 of the Constitution, which has been permissibly updated by Section 163 of the Electoral Act, requires that parliamentarians must be a subject of the Queen, either natural born or naturalised for at least 5 years and at least 21 years of age, now reduced to 18. But different from a constitutional concept of citizenship. There is no Australian constitutional concept of citizenship. There's no such thing as a constitutional Australian person. Neither is there any constitutional magic in being born in Australia, as Shane isn't here at the moment, but he and would well recall in the case of Koroita Mana in the Commonwealth, he and I unsuccessfully tried to persuade the High Court that young Fijian persons born in Australia were not constitutional aliens. The High Court said they were constitutional aliens because there was no constitutional guarantee that simply because you were born in Australia it had any constitutional significance, and they didn't otherwise qualify under the Migration Act, so they were constitutional aliens.
Well,
it's a different question.
If you're an alien, does that help, the fact that there's an idea of alien within the Constitution?
In at least 2 cases, the High Court has made it clear. Patterson's the first of the cases, is it not, Tom? Gaudron, Jay and Patterson said that the cases are separate. The case of whether you're a constitutional alien is not the same thing as the question of whether you're disqualified under Section 44. For example, although the analogy is not complete, you can be stateless. In the 20th century, and Koroita Mana has a discussion of the concept of statelessness. If you're a stateless person, you can be an alien. If you're a stateless person, you won't fail on that ground under Section 44(1) because you don't owe allegiance to a foreign power. So they're different. And that's made clear by at least 2 judgments of the High Court. On the other hand, in the United States, the constitutional significance of being a natural-born citizen is well known, and we all have read the papers. And we're all familiar with the recent, or now not so recent, debates about the actual birthplace of President Obama. The debate on who is a natural-born citizen continues to this day in the States, and the support for the theory that a natural-born citizen includes children born abroad of American parentage, covered by the Naturalisation Act in 1790 in America, who would be eligible as elected president, we've dealt with on page 7 of our paper. The US Constitution imposes limited eligibility requirements on people, the President, members of the Senate and the Congress, which we've dealt with in our paper. The approach is not the same as ours, although the underpinnings are the same, namely the starting point, the big picture point is participation in a democratic system. The US Constitution imposes 3 eligibility requirements on the presidency. Person must be 35 years of age, a natural-born citizen and a resident for 14 years. Ditto the Vice President. As far as the Senate and the representatives of Congress are concerned, the standing qualifications are expressly set out in the Constitution. 25 years of age for the House, 30 years for the Senate, and citizenship of at least 7 years for the House and 9 years for the Senate, and as well as inhabitancy of the relevant state. Those qualifications are the exclusive qualifications for being a member of Congress. Congress can't alter them, and the only real qualification, again dealt with in our paper, found in Article 1, Section 6, is that no person holding any office under the United States shall be a member of either house during his continuance in office. And that has seeds of some of the things you see in Section 44(5), but not the same thing, because the disqualification in America is not one in terms of standing for office. It's a disqualification in terms of holding. So their approach is to say just because you're holding, you've got a position with the US doesn't mean you can't stand. It means that when the process is over, you can't be both. Whereas, as we'll come to see in greater detail, our approach is that the approach in Section 44 is a different one. As far as the historical underpinnings in the UK are concerned, and again, I pass over a great amount of the detail in Part 1 and commend it to your attention, but it's not timely to go further into that now. But as far as the UK is concerned, English nationality was traditionally founded on the principle of the jus soli, as affected by the decision in Calvin's case, which was statutorily based, but resulted in a position whereby any person born within any territory held by the King of England could enjoy the benefits of English law and would in turn owe allegiance to the sovereign. You owed allegiance to the sovereign as a subject, and that word subject is a word used in contradistinction to the word citizen. The statutory ancestor of the provisions excluding foreigners, even naturalised foreigners, from serving in the Houses of Parliament flowed from the English Act of Settlement in 1701. And as Tom observed when he was researching this, there is an exquisite irony in the 1701 Act in England where you find the origins of the exclusion of foreigners, which, as those of you who've got any interest in history will know, roughly approximated the arrival on the English throne of the Hanoverian kings, the first of which who couldn't speak English and who had never set foot in England at the time of ascension to the throne. However, it's minor matter. Legislation prior to 1868 gave to the respective houses of the UK Parliament jurisdiction to determine questions respecting qualifications of office. And so it was something dealt with in Parliament under that prior legislation. And then in 1868, the Parliamentary Elections Act in England conferred the rights on the judges of the superior courts of common law exclusive jurisdiction to determine disputes as to the election and return of members with grounds of disqualification under the Act, including alienage. And that legislation was picked up by some of the Australian colonies. And that, in very short order, was the legislative background to what we saw at the time when the convention debates took place and Section 44 found its way into the Constitution. The second part of our paper, and I call the second part the non-comparative law aspect, looks at Section 44 itself, and you'll have seen that we've annexed the text of Section 44 for convenience at the back of the paper. So you've got Section 44 set out in convenient form there. That section, as you can see, it has characteristics talking about ability to be chosen and stand, general characteristics, but it identifies separately a number of diverse exclusionary provisions, some of which have or are achieving more prominence than others. Currently, those most notorious by far, are the exclusionary words in section 44.1, which is the sexy part of 44 at the moment, because it's the one that's getting all the attention. But significant questions also arise under sections 44.2 and 5. Now it's plain that a full analysis of all the questions which might arise in relation to the various provisions is beyond the reach of the paper, and certainly beyond the reach of this brief discussion, which will place some focus on the governing words of the section, and sections 44.1 and 5 particularly, and we'll see how we go. But I don't want to outstay my welcome. There's a lot that can be said about all of this, as you can readily see, and I want to say something about 44 in its generality. I want to say something about the governing words. I want to say something about section 44.1, which is where the action is, and if time permits, something about section 44.5, and time may not permit. Now, generally, as a matter of interpretation, constitutional lawyers are well used to dealing with instances where the denotation or the connotation of constitutional expressions used by the framers have developed since 1901. We can all conjure up examples. The conciliation and arbitration power is one, where the notion of industrial disputes grew from what would have been an understanding in 1901. Postal, telegraphic and telephonic under section 51.5 embraces television and who knows what else. We know about those constitutional concepts. But what we've seen in the case of the exclusionary provisions of section 44 is a situation in which the assumptions of the framers, or what can be confident, so much of their intentions as could be confidently assumed, have been, well, as to what the terms would or would not embrace, have been turned upside down by the development of Australian legal thought in relation to Australia's role as an independent nation. So this has found ultimate reflection in the case of Sue and Hill, which you'll find referred to on pages 16 and 17, where the court in 1999 departed from its earlier expressed view, and firmly expressed view, that the United Kingdom was not a foreign power at federation, and determined that the transformation of the Australian relationship to the United Kingdom, culminating in the passage of the Australia Acts, resulted in the conclusion that the UK had become, by some process of metamorphosis or statutory enactment, a foreign power for the purposes of section 44.1. The implications for persons of British heritage then became obvious, and we're seeing that, amongst the other things, unfold in the High Court as we speak. Likewise, in the case of section 44.5, as we can see, and if you look at the case of Day, which may or may not get time to pick it up, the reach of the provision has been judicially expanded by an appreciation of the fact that its purpose is broader than previously determined, so that section 44.5 had to be approached on the basis that it was not simply directed to protecting members of Parliament from influence by the executive, but was directed to ensuring a proper discharge by members of Parliament of their duties on behalf of the Australian people. That was what got Day ultimately, and that's why the court disapproved of an earlier decision of Chief Justice Barwick, which took a very narrow view of the reach of section 44.5. So again, there are influences in recent decisions of the court which, when people get around in October to saying, please read this down and that down, are going to be part of the conversation. What then was the statutory and factual context underpinning the introduction of section 44? At the time of the Convention debates, as we've seen, the relevant UK legislation excluded MPs who owed allegiance to a foreign power, a historical consideration that no doubt prompted the framers to introduce a similar restriction into the Constitution. Attempts to divine what the framers were actually considering engendered our recourse in the paper to the passage on the bottom of page 8 of our paper, where and which inspired our title, namely that a search for the intention of the framers was a search for something as enigmatic as Pharaoh's dreams. And that was a quote, I think, from Justice Jackson. Now, of course, recourse to the convention debates is one thing. Since the Section 92 case of Cole and Whitfield, the court has been more prepared to have recourse to the convention debates, and there's been some recent discussion in Section 44 context that the convention debates are a useful tool, but of course problematic. It's probably a digression, but I can't help myself. My favourite quote in relation to the difficulty of recourse to the convention debates is the quote from Gleeson CJ in Singh in the Commonwealth, one of the aliens cases, where Chief Justice Gleeson said, and I'm sorry, it's more than a couple of lines, "The public record of the convention debates is evidence of what some people involved in the framing of the Constitution said about various drafts of the instrument. It's the partial record of the drafting history of most of the provisions of the Constitution. It reveals what some people understood, knew, believed, thought or intended about the proposed instrument and the circumstances surrounding some of the events in preparation. What the record shows about the subjective beliefs or intentions of some people may be interesting, but of itself it's not a relevant fact. Many people in Australia and the United Kingdom were involved directly or indirectly in decisions about the form of the Constitution. Not all of them participated in the convention debates. Furthermore, and this is my favourite part of the quote, as at all gatherings of lawyers and politicians, those who had the most to say were not necessarily the best informed or the most influential."
What about the best evidence rule?
Yes, I know. However, he did go on to say that an examination of the debates may serve some purpose in throwing light on the meaning of a provision depending upon the problem of interpretation that arises, and we all know the rules.
Could I interrupt? I'm sorry, I haven't read the paper, but when you just described that Sue and Hill decision about the transmogrification of Britain as a foreign power, that seems to be a pretty big day at Black Rock.
It was. Massive day.
It just seems to be odd that it wasn't obviously it wasn't a foreign power at the time, because we were all one happy family, a British bloody organisation, whatever, Commonwealth, and then they say, well, but you were transmogrified into something different.
Correct.
By legislation here.
Well, you've missed the biggie, and the biggie was that the Constitution was itself an act of the UK Parliament.
Well, you know,
Enough said. And well, those arguments were considered and rejected in a number of cases. Patterson is one of them. Tom, the immigration cases. Shane should be here.
There's a paragraph in there that talks about the main sort of anchor points that they point to the join the dots.
Statute of Westminster, the culminating in the Australia Acts.
Yeah, well, I apologise, I haven't read it, but does it mean is one way out of this difficulty to revisit that and to say that that's wrong?
That would be a sectional. That would
help some people.
No, I think you can pretty confidently say that whatever is going to be the exit from the current debate is not going to see a reversal of Sue and Hill. That is well established. The implications of Sue and Hill go well beyond the need to preserve a few politicians. This is a fundamental decision that has to do with Australia's role in the international community as an independent nation, and the reasoning in Sue and Hill, which, as you say, was a big day at Black Rock, one of the biggest, was based upon an examination of constitutional history over a period of time, which it's like trying to define a dog. You get at the end of the day to something that's got 4 legs and barks, and you can say that one's a dog, but you can't quite say when it evolved into a dog. That's the reasoning in Sue and Hill, and it will not go away. It would be an amazing turn of constitutional events if Sue and Hill went into reverse. So the solution is going to be found elsewhere, and not by virtue of a reversal of a judgment which actually deals with a section of the population, a big section, but a section. The factual context at the time of the debates was this, that at the time of the first convention debates, the total population of the Australian colonies was close to 4 million, of whom 1 in 4 was born overseas. To say nothing about the massively greater number of persons who were children of parents born overseas. To take one example, Melbourne as a city was purchased from the indigenous population less than 50 years before the first convention debates. Then there were the gold rushes, then there was the arrival of a whole lot of people, including people from Europe as well as England and America as far as the gold rushes, big German populations, Chinese people, they were all there. Sir Henry Parkes, who gave the Tenterfield oration in 1889 and who was President of the Constitutional Convention and known as the Father of Federation, was born in Canley, Warwickshire. The first and second Australian Prime Ministers, Barton and Deakin, respectively, were born of English parents. And you'll have seen the stories coming out in the paper today. Tony Abbott was born in England, and the story goes on. The High Court has said in Section 44 cases, this was the picture then, it's the picture today. King O'Malley, who was a member of Federal Parliament from 1901 and who was Minister for Home Affairs at the time of the choice of Canberra, and Walter Burley Griffin as its architect, was actually born in Kansas, although he alleged until late in his life that he'd been born in Canada. This is not a new story, folks, and it's not as though we have these people there today but that they weren't there at the time of the Constitution. So it is not a denotation and connotation sort of thing. It's not new. What were the framers thinking when they drafted Section 44.1? Back to the Pharaoh's dreams. What you can be sure of is that they had no idea that it would be ultimately excluding those born or descended from those born in the UK in circumstances where they were in the business of drafting a constitution which would be a creature of the United Kingdom Parliament. The thinking was, of course, turned on its head in Sue and Hill. And now we see, of the numerous politicians whose cases have been referred to the High Court, at least 3, Joyce, Nash and Roberts, and more distantly Xenophon, he's different because he comes from Cyprus and he's a British overseas national, coupled with the critical consideration to which I will return, it's an important one, that Section 44.1 is to be approached on the basis that allegiance will be determined by the law of the overseas country in question, leads us to where we are or are about to be. Coming to the paper, we deal with some general matters concerning Section 44 on pages 8 to 10, and I'll be brief in relation to this. These are general considerations, but they're important before coming to the sexy a bit about what Section 44.1 means and what it might mean. In a constitutional sense, Section 44 appears in immediate proximity in the Constitution to a group of provisions, which we identify on page 9 of the paper, which make constitutional provision until Parliament otherwise decides. They've each got that expression. Section 46, 47 and 48. And on page 9 of our paper you can see what those sections are and what they do. So we have, leaving aside Section 16, which makes the qualifications for the Senate the same as the reps. Section 43, you can't sit in both houses. You can't be chosen as a member of the other house. Section 45, which provides that if a senator or member of the House of Representatives becomes subject to any of the disabilities mentioned in Section 44, or takes the benefit of a bankruptcy law or tenders a fee for service reduced to the Commonwealth, that person's seat shall become vacant. Difference between Section 44 and 45 is obvious. 45 deals with an ineligibility that arises after a successful and valid election, and the difference is that it actually prescribes the result and says that if that happens, your seat is vacant. So that's an automatic result, to which I'll come back.
That's Max, that's because it shows that you've taken a conscious decision to do something that seemed to be inimical to the interests of Australia.
Yes, it deals with conscious activity.
Which helps, does it not, in terms of the current debate?
Well, it probably does. When you stop to think about it, it assists in the argument that as to the potential reading down of section 44(1), which again I'll come back to. But the answer to that is most assuredly yes. Section 46, financial penalty. There's still, if you sit and you're ineligible, there's actually a financial penalty under the Constitution. These things have been replaced statutorily, and we've set out in the footnotes, I don't go to them now, how they've been replaced. Section 48 provides for an allowance of a designated amount, and you see the tension in section 48 as something that's been referred to by Justice Keane in recent times. Section 44(5) provides that you can't stand for Parliament if you've got if you are subject to a benefit from the as a result of an agreement with the Commonwealth. So Senator Day had a complex series of arrangements pursuant to which he had an expectation of financial benefit from the Commonwealth and was excluded when we come to look at the facts. But the tension is that, of course, if you pay peanuts, you get monkeys, and the constitutional framers were conscious of the fact that there was a need to actually pay parliamentarians. And where were they paid from? They're paid by the Commonwealth, aren't they? So section 48 is a resolution of what was described by Justice Keane as the dilemma and the reconciliation as between pragmatism and purity, and provides for a statutory payment of politicians. And now there's a system under the Remuneration Act, the Remuneration Tribunal legislation, regularly updating the pay from the Commonwealth to parliamentarians. And section 44(5) operates in an environment in which you're otherwise not permitted to take the benefit of a contract. And the question there will be, how far does that go? And obviously there's a point of ridiculousness where section 45 can't reach, which has been discussed in Reid Day. But
isn't that a reflection that Reid Day, he was the guy who had premises that were leased to the Commonwealth, was he not?
He was some. That's with the facts. The facts are set out there. He had an electoral office. He established an elaborate regime whereby the Commonwealth's payment in respect of the electoral office would pass through a series of companies and a lease which provided for at the end of the day for the exercise of a discretion which could be exercised by Day, which ensured that the payment, if he elected, could be received by him, and that was deemed to be a sufficient connection and an indirect benefit. And so there will be debates in the future. At the end of our paper, we refer, just casting ahead, to the next cab off the rank in relation to that, which will be Mr. Gillespie, and Dr. Gillespie. And Gillespie has he owns a shopping centre in Port Macquarie, and he one of the areas in the shopping centre is leased by Australia Post. So that will be the next point of debate.
In terms of conceptual idea, Day seemed to me to smack of the idea of a straight conflict of interest, that somehow that you own property and you're doing dealings with the government, and that's what we certainly don't want as people in Parliament who have any sniff of a conflict of interest. And this bigger question that we're now looking at is only another manifestation of whether there is a conflict because you have some association with another company.
Well, they're different. They're different. They're both questions of. They're different.
They're different. The idea is the idea, isn't it?
No. It's not. It's not. That's not. It's not. It's not correct. It's not.
I'm talking about corruption. I'm talking about the idea that if you have an allegiance to another country, that we don't want you having any say in the way we run our country.
Yeah.
Because that could be a conflict of interest in how you go about your functions.
In some senses, you could see. You can see a connection in terms of conflict as between some of the provisions in section 44, but the actual aspects of protection that's provided, for example, in section 44(1), goes beyond aspects of conflict of interest.
I understand that.
It has historical connotations and backgrounds that have nothing to do with conflict, but have to do historically with, for example, historical fears about being dominated by. Well, it's fears about being dominated by people who aren't in in Parliament, and these things transcend conflicts of interest. So there are some issues of commonality, but the underpinnings of the provisions are different. And one of the aspects of Section 44 that's significant is it has a number of different arms, and the approaches to construction of the different arms might conceivably be quite different, so that the potential for a narrowing of an approach to Section 44.1 might not be the same as an approach to narrowing Section 44.5. So we see in Section 44.5 the High Court already saying we're not going to read that provision down because we want to protect. Section 44.1, when it comes to it, and this is the matter I alluded to earlier, is not necessarily going to be receptive to the same sort of reasoning. The High Court can be expected to be listening very attentively to arguments about how it might, the excesses of Section 44.1 might be dealt with. At the same time, both 44.1 and 44.5 have this in common, that read literally, they can lead to either unsatisfactory or ludicrous results. In the case of 44.1, the result is that at the outermost limit, Australia surrenders, the Australian Parliament surrenders its capacity to control the question of what it is necessary to do to affect your coverage by 44.1, and we'll come to that. In 44.5, a literal approach means that any sort of contract and contractual dealing that a member of the Parliament has with the Commonwealth, buying a stamp, a postal note is the example, is caught. So there will be pressure to read it down, and in Day, the court said, look, we're not exploring or some members of the court said, we're not exploring the outer limits of this because we can all see that it's silly at the outer limits. So we're not doing that. What we're doing in the case of Day is we're saying, whatever those outer limits are, you're in it. So there are very different considerations that will apply to approaches taken to the different subparts of Section 44.1. Earlier I noticed that our colleague Brett Walker, he's in the happy situation, it'd be good to have a brief in some of these matters, that Brett Walker has two briefs, in one of which he is acting under, I think, 44.1 and 44.5, and he will have very different tasks in discharging his brief, because in one of them he will be inviting a narrow approach and in one of them he won't. However, I digress. The mechanics, I'll pass over this quickly. The way in which we get to what's going on now, we discuss in our paper in the context of the steps that have been taken under Section 51(36) of the Constitution to legislatively provide for the matters where the Constitution said, until otherwise provided for, this will be the constitutional go. And they include the establishment of the High Court as the Court of Disputed Returns, and the substitution of Section 163, qualifications for sitting in Parliament, and various other matters. The penalties for sitting and the like have been subsumed legislatively. The establishment of the High Court as the Court of Disputed Returns has led to the situation where the Court of Disputed Returns has been established as the exclusive tribunal in relation to the treatment of the dealing of alleged ineligibility, and it has been held by the High Court that the Court of Disputed Returns, when it exercises that exclusive power, can exercise it in relation to matters concerning Section 44 as well as legislative invalidity, and it has been held that although the Court of Disputed Returns is exercising power that previously would have been exercised by the House in disciplining and ejecting its own ineligible people, the Court of Disputed Returns is exercising the judicial power of the Commonwealth. Now, as to the consequences, well, there are two other general matters I want to just say something about before coming to the text of 44.1. It's also important to consider the effect of the words, if you go back to the annex, the words incapable of being chosen or sitting, which govern Section 44. In Sykes and Cleary, there was a question arose as to what those words meant, and in Sykes and Cleary, the Court of Disputed Returns held that those words were determined to be a reference to the process of being chosen, and that process, which starts with the nomination and ends with the issuing of the electoral writs, that has the important consequence of rendering irrelevant any attempt by the candidate to remove the basis of ineligibility before the declaration of the poll. Small matter. So that in that case, Cleary, who was said to be disqualified because he was a teacher, a state school teacher, he was on leave actually. He was taking leave without pay, and he said, "Look, how can this be me?" The High Court said, "It's you. You don't have a particular state teaching position. There's no such thing as a teaching position. You're in the state teaching service, taking money from the Crown. Doesn't matter that you're a state employee as opposed to a federal employee, because the 44 is designed to exclude both. And it doesn't matter that you're on leave without pay and aren't taking a shekel. You're in, and neither does it matter that before the declaration of the poll you resigned from the teaching service, because the process is one of being chosen, and that's
Is that something that they could now resolve from? That would also make things easier.
Oh, well, it wouldn't make things necessarily much easier. It would. We're only talking about steps before the declaration of the poll. We're not talking about people who discover after the election that they've got a problem. So it would have a minimal.
Haven't they, after they've been
Yeah, Cleary got onto it early, and the issue arose early days. Cleary said, "I'll resign," and that was tested in the court, and that didn't work. So 44 has application to the process.
But it's not an inclusive decision. It doesn't encourage people in the public service to nominate for Parliament because they have to quit their jobs. So you're right.
The problem with going the other way would mean that you can have more and more of the fuck-ups that we're now encountering. If people say, "Well, bugger it, I'll see how I go and I'll worry about it if I get chosen."
We
I
still
don't.
have certainty if you said that the cut-off date is when the declaration of the poll is, though. It would be more inclusive that way. But anyway, sorry, Michelle.
No, it's fine. It's simply laying the groundwork to what does 44 do, and 44 operates. Sykes gave it a pretty generous field of operation, for a number of reasons. It applied to the states, it applied to people who'd resigned, it applied to people who were on leave. It was a inclusive decision. Inclusive in terms of what was covered by Section 44. Our paper also addresses the legal consequences for the election itself flowing from a finding that a candidate is disqualified. This is dealt with on pages 12 to 13 of the paper, and although it's a lengthy discussion, I'll be very brief, I promise you, and get down to reality. But and pizza. Section 44 applies equally to the Senate and the House of Representatives as a result of Section 16 of the Constitution. In the case of a Senate election, where under the Commonwealth Electoral Act there is provision for above the line and below the line voting, as we all know, and the identification of eligible political parties above the line, the impact of a finding of ineligibility was addressed in re Wood, where my then client, putative Senator Wood, was not an Australian citizen, had an electoral, not a Section 44 disqualification, and the High Court, that having been disclosed in circumstances which followed upon our earlier successful case resisting challenges to him, intervening parties sought to have the entire electoral process revisited, and it was the time of the Joe for Canberra campaign, and the Queensland government arrived in the High Court seeking a half-Senate election as a result of the admitted irregularity caused by Senator Wood not being Senator Wood. However, the court rejected that approach, determining that the votes cast for the ineligible senator would not be treated as thrown away, notwithstanding the complexities of the Senate voting process, which are Byzantine, but would be treated as valid except to the extent that the want of qualification made that particular indication of preference a nullity. So the result was that there was ordered something called a special count, which proceeded on the same basis as would apply if a Senate candidate died during the election. The net result was that the next in line representative of the Nuclear Disarmament Party was declared elected following the special count. So there was no fresh election. I won't tell you what happened 4 years later when she declined to give Senator Woody's seat back, but that's another story. A different situation applies in the case of a House of Representatives election, as determined in Sykes and Cleary again. In that case, the High Court addressed the situation in which there was a field of candidates for election in the House and determined that a finding that a candidate declared elected was in fact ineligible, Cleary, would give rise to a distortion of the voters' intentions if a special count was conducted. Because of the range of possibilities, you wouldn't know what people would have done had they known that the ineligible candidate wasn't there. So in that case, there needed to be a new election. In the third type of case, which is the case caught by Section 45 of the Constitution, where an invalidity or an irregularity is discerned after a successful election, Section 44 grounds arise afterwards, there's a vacancy, and Section 45 of the Constitution says there's a vacancy. But that doesn't mean in that case there will be paradoxically a fresh election, because the Constitution there makes special provision in sections 21 and 15, and the Constitution actually makes provision for the notification to the relevant state governor and for a selection by the state governor in terms of the requirements of section 15 by way of a replacement. And Brian Burdekin is smiling here because he can remember what the Queensland government did before section 15 was amended. Some of you will remember that the Queensland government decided that they would play ducks and drakes and disturb the Senate, the pattern of Senate voting by selecting someone from out of left field. I think it was Senator Field. In any event. So it's important to understand what the consequences of all of this are or may be, and they will be diverse because we have a variety of people who are currently under examination. I think in view of the time, I want to say something about section 44(1), and I'll leave any discussion about other provisions aside. The starting point for 44(1), which you'll see the text and it's well known, is the critical acceptance that, at least as a matter of a general proposition, the question of whether a person is a citizen of a foreign power, and presumably the same can be said as to whether you owe allegiance to a foreign power, is to be decided by recourse to the classification given to that person by the law of that country. Gulp. This is obviously vital for a number of reasons. In the first place, it introduces into section 44 the prospect that disqualifying factors can be achieved by descent. If the law of the relevant foreign country applies, if it applies, and it applies the jus sanguinis and gives citizenship to progeny of a person who is, for example, born in Australia, may obviously be still a citizen of another country on this basis. In Nyland Wood, the first of the two cases which concerned my client in 1988, the High Court suggested without deciding that if you have done nothing at all to acknowledge allegiance to a foreign power, you may be okay. That was entirely untested at the time, but would be expected to be the first port of call for parties like Senator Joyce, who will assert that until recently they had no idea that they were potentially caught by the provisions because they were born in Australia and had never done anything themselves to take the benefit of foreign citizenship or to pledge allegiance to a foreign power. If that is accepted, there may be some basis for a distinction between the position of, for example, Joyce and that of persons who have previously knowingly taken the benefit of being a citizen of a foreign power, that is, someone who's been a foreign citizen and has come to Australia and been naturalised. And I'll say something just in a moment before I stop about having read the Solicitor General's submissions to Chief Justice Kiefel yesterday about where this argument is going, and it's going here. If it is accepted that allegiance or citizenship may be legally capable of being renounced or repudiated, acceptance of the starting the principle that it is the law of the foreign country that is determinative of matters identified in section 44 has direct significance for the identification and nature of steps necessary to effect or attempt such renunciation, and that leads to an examination of the facts in Sykes, and we've set out the facts in Sykes in some detail because they're important for an understanding of all of this. The basis of the attack in Sykes was on Cleary himself, as I've said. He was a teacher under 44(4), but an additional attack in that case was made on two other candidates under 44.1, the Liberal and the Labor candidate, and we've set out the facts in relation to those candidates on page 14, halfway down the page of our paper. There was a Swiss person, a person of Swiss origin, and there was a person of Greek origin. Both of those people had been born overseas and had gone through a process of obtaining Australian citizenship, a process which after the 1990s, you will note, has actually statutorily required an applicant for Australian citizenship to renounce to the Australian authorities former citizenship. They'd both done that, but both were held ineligible. If you look at the facts of those relevant to those people, you will see a story that perhaps has some familiarity to some of the stories that the High Court's going to hear in October. The Labor candidate, Mr. Kardamitsis, he was a candidate for Wills. He's living in the northern suburbs of Melbourne. He's been out here for years, since he was very young. He's a JP. He's only ever travelled on an Australian passport. He's gone to the Australian authorities. He's renounced to the Australian authorities his Greek citizenship. He's living in the northern suburbs of Melbourne. I bet he barracked for Carlton on the weekends and probably never thought of himself other than a dinky die Oz. Poor bastard. He was disqualified because he was held. The one thing that neither he nor Delacretaz, the Swiss person, had ever done is to make application to the Swiss or Greek authorities as they were able to do, because both Greece and Switzerland permitted a process of renunciation. And the members of the court, the plurality, talked about, in those circumstances, the question of whether, well, okay, you haven't taken, you could take steps to renounce, but you haven't taken any sufficient steps and you're gone. Justice Brennan had a judgment in the middle, and Justice Dean, who dissented, said, look, the process of determining constitutionality by reference to things like that is not necessarily the watchword, and we've set out in our paper his much broader approach to these matters, and applying Justice Dean's approach would also be one of the ports of call of the candidates in the October proceedings. The significant thing about, however, about all of the judgments in Sykes concerning section 44.1 is that all of them, the plurality, Justice Dean, Justice Brennan, all proceeded on the basis that the principle that you had recourse to the law of the foreign country was not immutable. Because if it was immutable, the Constitution says nothing about reasonable steps to renounce or anything like that. All of the approaches involved an inroad into the immutability of that. And so the question, and here is the lie of the land, and the likely lie of the land in terms of constitutional argument in October in relation to 44.1. What is the watchword? Does it ultimately have anything to do with reasonable steps? Is reasonable steps the test, or is the test a broader test? And the test that is suggested as the broader test is the test of whether, or maybe the test of whether, as Max has been suggesting, you've actually gone out and done anything in the first place. So here we are, we've got Barnaby Joyce, who never knew, or says he never knew, that he was a Kiwi. He's just been nominated for New Zealander of the Year award, I saw. And we have the others in Cleary who knew that they'd been taken the benefit of foreign ownership, but foreign citizenship, but they thought they had done enough, but hadn't. What is the way forward without doing violence? Well, I took a look at the transcript of proceedings before Chief Justice Kiefel yesterday, and as chance would have it, the Solicitor General appeared, and because he was seeking to tell the court how quickly things could be done, he summarised the argument that the Commonwealth would run, drawing a distinction between these types of people. Does Joyce have a better case than Delacrete has, or is it the reverse? And he said this, and I'll sit down after I've read this very briefly, I promise you. The starting point in the Commonwealth submission is that this court has already held in Sykes and Cleary that section 44(1) of the Constitution does not give unqualified effect to the common law rule that whether a person is a citizen of a foreign power depends on the law of the foreign country. In our submission, the entire court held in Sykes that 44(1) should be construed having regard to its purpose, which required some narrowing of the extent to which the Constitution would recognise the effect of foreign law. The purpose of the provision being identified, in that case, in various ways, but generally by reference to the need to ensure that members of Parliament do not have split allegiance and are not subject to improper interference from a foreign power. From that starting point, the court in our submission recognised that foreign law is only to be applied in identifying foreign citizens for the purpose of 44(1) in circumstances where the application of foreign law will turn that identified, will fulfil that identified purpose. And the point was, we respectfully submit, well captured by Justice Brennan in the judgment. Our submission will be that consistently with these observations, foreign law is not to be applied in identifying where a person is a citizen or a foreign power, where the person does not subjectively know that they are now or have at any time been a citizen of a foreign state. And on that approach, we submit there is a clear demarcation line where a person does know that they are or have been a citizen of a foreign power. That is the Sykes and Cleary situation. That was the position of both of the people who were considered in that case, and the court has held that in that situation the person needs to take reasonable steps. So some people are going to go down by the bow, and some people are not.